Hello, hi guys. This is Balakrishna from Lecturepedia.in. How are you? Hope you people are doing well. Even I am fantastic. In the today's class, we'll be starting a new chapter, which is prevention of oppression and mismanagement, which is sixth chapter of Companies Act for self-paced online module set A. Now if you see this chapter, it is a very small chapter. There are only 6 sections in this chapter, section number 241 to section number 246. Let us start this chapter. Now before starting the chapter, first of all we'll understand the terms that are used in this chapter. I guess you might be listening this term oppression for the first time. So what is meant by oppression? Oppression means nothing but acting in a way that you are taking away the rights of the shareholders. Okay, let's say for example, in the company, to take any decision, the shareholders, they'll take the decision, right? Now here in the company, the majority shareholders, they are not considering the views of minority shareholder. Here you can call this situation as majority shareholders oppressing the minority shareholders, or majority shareholders are acting in a way wherein the rights of minority shareholders are being taken away. Let's say for example, company has declared dividend. Now dividend means it needs to be given to all the shareholders, right? Because all the shareholders, they will be having shares, and for their shares they will be entitled for dividend, right? Now here the management, they have given dividend only for certain 80% of shareholders. For remaining 20% of shareholders, dividend not given, or dividend has not been declared. Now this is a clear case of oppression, where you are acting against the rights of some of the shareholders. Or company, the management of the company, they are incurring certain expenditures, and they are not informing, or they are not giving access, they are not giving correct information about those financial transactions to the shareholders. Even this is also a type of oppression, right? You are not allowing the shareholders to access the books. Shareholders, they are having right to access the books, but you are not allowing them to access the books. So here also you are taking away the right of the shareholder, or you are acting against the rights of the shareholders. So this is known as oppression. So whenever any oppression in the company happens, then shareholders can complain about this oppression to the tribunal, to the National Company Law Tribunal. Okay, so that is about oppression. Next, mismanagement. Mismanagement, that means you are not managing the company in its best interest. Let's say director is using assets of the company for his own purpose. This is a mismanagement. Or you can purchase the raw material from a particular vendor at some 100 rupee per kg, but you are wantedly purchasing the same raw material from another vendor who is very close to the director at rupees 150 per kg. So here it is not in the best interest of the company. You are mismanaging the company, right? Because of your mismanagement, the company is suffering the loss. So this is known as mismanagement. Even against this mismanagement also, shareholders can file a complaint with the tribunal. Okay, I hope you understood the meaning of these two terms, operation and mismanagement. Okay, in case of operation, you are acting against the rights of the shareholders. In case of mismanagement, you are mismanaging the company. You are not properly managing the company. Okay, now, so whenever any mismanagement or any operation takes place in the company, you can file application with the tribunal under section 241. Okay, so what are the various situations in which application under section 241 can be filed? Let us see those situations. First of all, by any member of the company. Okay, in which cases member of a company can file application to the tribunal under section 241. Here member means shareholder. Okay, so let us see. Affairs of company conducted prejudicial means not in the best interest or against the best interest is known as prejudicial. So if affairs of the company are being conducted prejudicial to public interest or prejudicial to the interest of himself means shareholder himself, or prejudicial to the interest of any other member, okay, or interest of the company. So if the company's affairs are being conducted in a manner which is prejudicial to the public interest or to the interest of himself or to the interest of other members or to the interest of the company, in these situations member, that is shareholder, can file a application under section 241 with the tribunal. Okay, next, the member can also file application to the tribunal if there is a material change in what? Material change in management. Management means top management, like managing director, whole time director, manager, okay, key manager, personal, CEO, CFO. So if there is any material change in the management or control of the entity, control of the entity means who will control the entity? The shareholders will control the entity. Okay, whoever is having a majority shareholding, they will be having the control over the company. So if there is a change in the control of the entity and such change is not in the interest of creditors, debenture holders or shareholders, okay, because of such change the creditors or members or debenture holders are incurring some loss, okay, because of change in the top management or because of change in control of the company, the members, the debenture holders or the creditors, they are suffering loss. Okay, the change is against the interest of these people. In this situation also, any member of the company can file a application with the tribunal. Okay, however, to file application to the tribunal under section 241, there is some eligibility criteria. Okay, certain minimum number of members must be there to file the application. We will see that eligibility criteria in the next section. Okay, so here members can file application under section 241 to the tribunal in case of following situation. Okay, if there is any operation or if there is any mismanagement. Next, application to the tribunal can also be filed by central government. Okay, the central government itself can file an application to the tribunal under section 241 regarding operation or mismanagement. Let us see. By central government, if in its opinion, okay, if central government feels that affairs of a company are prejudicial to the public interest, okay, the company is conducting its affairs which are prejudicial to the public interest. Let's say this company is involved in some terrorism activities, or this company is manufacturing some illegal weapons. So these kind of activities are against the public interest, right? So in this situation, the central government itself will file application to the tribunal under section 241 against the company. Okay, here the application will be mismanagement application. Okay, next, central government will also file the application if in the opinion of the central government, person concerned with conduct of management is guilty of fraud or misfeasance. Okay, if the central government feels that the person who is conducting the management of the company, that is either the managing director or whole time director or any key managerial personnel, is involved in fraud or he is guilty of any misfeasance, in such a situation also central government will file application under section 241 with the tribunal. Next, if central government feels that business is managed with no sound business principles and commercial practices, okay, if the business of the company is conducted without any proper sound business practices and commercial practices, in this situation also application under section 241 will be filed by CG. Next, if business, if there is a serious injury to the interest of the trade or with an intention to defraud its creditors or members, okay, the company is conducting its business with an intention to defraud its creditors or members, like it has taken goods on credit basis but it is not repaying the amount, like this every time to every creditor it is doing the same. Okay, first time it has purchased raw material with creditor 1 and it has not paid the amount, it has shifted to creditor number 2. For creditor number 2 also it has not paid the amount, shifted to creditor number 3. So here the company is doing the business with an intention to defraud its creditors. Okay, and serious injury to interest of trade. Okay, serious injury to interest of trade means, let's say for example, the company is manufacturing forgery products, fake products, like let's say for example in the market you can find, for example, shoes, Nike shoes, right? So the brand Nike, it will be used only by the respective brand owner. Now without taking any permission, the company is using this logo and manufacturing the shoes. Okay, so it will cause a serious injury to the trade, right? You should not illegally use other trademarks, it is offense, right? In these situations also company, the central government can file application under section 241 against the company if there is a serious injury to interest of the trader. Next, however, the following situations should not be understood as an operation. Let's say company failed to declare dividend. See, company failed to declare dividend to all the shareholders. Okay, for all the shareholders it has not declared the dividend, it is not an operation. Why? Because in the current year company is not having profits, so it has not declared dividend. Okay, it is optional, it is at the decision of the company whether to declare the dividends or not. If the company has not declared dividends to all the shareholders, then it is not an operation. But it will become an operation if company has declared dividend to some shareholders and it has not declared a dividend to some other shareholder. Okay, this situation will be operation. But if has not declared dividend to all the shareholders, then that is not an operation. Next, continuous losses. If the company is incurring continuous losses, this is also not any operation. Okay, might be really the financials of the company is such that it is incurring losses, or really the market is such that the company is incurring losses. So continuous incurring of losses doesn't mean that there is operation in the company. Hope that is clear. Operation or mismanagement in the company. So that is section number 241. Next, section number 244. I have told you now, in order to file application under section 241, there should be certain minimum number of shareholders who should file the application. So what is that eligibility criteria to file application under section 241 is discussed in section number 244. See, section number 244, right to apply under section 241. See, if the company is having share capital, okay, if the company is having share capital and the shareholders of such company wanted to file application under section 241, then at least this many members should file. See, lesser of at least 100 members or at least 1/10 of the total members or any member holding 1/10 of issued share capital. Okay, these many members should file the should be there to file the application. See, the first situation, at least 100 members or 1/10 of the total members. Let's say for example, company is having only 50 members, total shareholders itself is 50. So 1/10 of 50 is 5 shareholders, right? 5 members. Now lower of 100 members or 5 members, which one is lower? 5 members is lower. So in case of this company, to file application under section 241, at least 5 members must come together and file the application, or any member holding 1/10 of the issued share capital, he himself can go and file the application. Let's say for example, total share capital of the company is 1 lakh rupees. Now 1/10 of 1 lakh rupees is 10,000 rupees. So shareholders holding the share value of 10,000 rupees, which is issued share capital of 10,000 rupees, they can come together and file the application under section 241. Here this 10,000 is face value, not the market value. Okay, and issued share capital, it is issued share capital, not subscribed share capital, not paid up share capital. It is issued share capital. See, let's say company is having authorized share capital of 1 lakh rupees. Okay, of these authorized share capital of 1 lakh rupees, company has issued only 50,000 rupees of share capital. Okay, company has issued 50,000 rupees of share capital. Of this 50,000 rupees share capital, paid up share capital is only 25,000 rupees. That means you can issue the share capital and you can ask the members to pay the amount in installments, right? At the time of issuing, you will collect application money. After that, you will make call number 1. After that, you will make call number 2. Like this, in form of calls, you can collect the amount, right? So as of now, the paid up share capital in that issued share capital is just 25,000 rupees. Now here, for the purpose of calculating this 1/10, you must use this issued share capital. Okay, not authorized share capital, not paid up share capital. You have to use issued share capital, and issued share capital of both equity and preference share capital to be considered. Okay, hope this is clear. So this is the minimum number of members who has to file the application under section 241 if the company is having share capital. Let's say if the company is not having share capital, okay, there will be some companies which are incorporated on the basis of guarantee, right, which are limited by guarantee. So if the company is not having share capital, then at least 1/5 of the total number of members must come together and file application under section 241. Hope that is clear. And some important points. See, See, shareholding of petitioner reduced below 10% due to fresh issue which is being challenged. Petition is valid only. Let's say at the time of the application being made under section 241, the petitioner is holding 10% share capital. Okay, 10% share capital means 1/10 of the total share capital, right? So if you are holding 1/10 of the total share capital, you are eligible to file application under section 241. So you have filed application under section 241. But after filing application under section 241, company has made fresh issue of share capital. Okay, if a fresh issue of share capital is made, then these shareholders shareholding will dilute, right? Let's say earlier 1 lakh rupee share capital is their issued share capital. Of this 1 lakh rupees, this particular shareholder is holding, let's say 10,000 rupees worth shares. So 1/10 he is holding. So he has filed an application under section 241. But after filing application, company has issued a fresh issue of another 1 lakh rupee. So existing share capital of 1 lakh rupee plus fresh issue of 1 lakh rupee, total it will become 2 lakh rupees. Now if total it has become 2 lakh rupees, but our shareholder who has filed application, he is still holding 10,000 rupee shares only. So his shareholding will be diluted to 5%. Yes guys, sorry, there was some issue with my mic, so the voice has stopped. I guess now you are able to properly listen. Now where were we discussing? This 5%, right? So because of fresh issue of shares, if the shareholding of the person who has filed the application under section 241 dilutes, even then also the application that has already been filed will be valid. Okay, next point, consent is reckoned at beginning of the proceedings. What is this? Now as per the requirement of section number 244, 100 members or 1/10 of total members. Let's say 1/10 of total members is 50 members. So lower of 100 members or 50 members, which one is lower? 50 members is lower. So 50 members has come together and they have filed an application under section 241. Now after filing the application, of these 50 members, some 5 members have withdrawn their support for filing the application. Now in this situation, whether the application that has already been filed, whether it will be valid or invalid, the answer is it will be valid, because the requirement of the number of members has to be reckoned at the time of filing the application. Okay, the consent of the members has to be reckoned at the time of filing the application. At the time of filing the application, 50 members were giving consent to file the application. After filing, they have withdrawn the consent. It doesn't matter, because at the time of filing the application, they have given the consent, so the application will be valid. Hope that is clear. Next, section number 242, which deals with powers of the tribunal. Now you have filed application under section 241 to the tribunal. After filing application to the tribunal, what powers tribunal will be having? Let's see. The tribunal is of the opinion that affairs of company are oppressive. See, you have filed application to the tribunal under section 241 stating that tribunal in our company there is oppression going on, or there is mismanagement going on. Like this, you have filed application with the tribunal. Now to accept the application, even tribunal also should feel that yes, in your company oppression is going on, right? So in the opinion of the tribunal also, affairs of the company are oppressive, and tribunal feels that winding up of the company would unfairly prejudice such members. See, wind up would unfairly prejudice such members. Okay, tribunal feels that yes, in your company oppression is going, but because of the fact that oppression is going on, if I wind up your company, there will be loss that will be incurred by the members. Okay, the wind up will not be in the best interest of the shareholders. So I will not wind up. Tribunal should feel this. Okay, what the tribunal should feel after filing the application: the oppression is going on your company, and winding up of your company would be unfairly prejudicial to such members or member. Okay, if tribunal feels so, then tribunal will order. What tribunal will order? Tribunal will order to regulate conduct of affairs of the company. Okay, tribunal will give a order. Because of these actions there is oppression in your company, na? Then I am giving an order stating that these activities should not be performed, right? That is regulating conduct of affairs, conduct of business affairs of the company. Next, transfer of shares to other members or restriction on transfer. Let's say if shares are transferred from current members to some new person, then there is a chance that the new person who will become the member might exercise the oppression over the existing members. In such a situation, tribunal will pass a order on restricting transfer of such shares to other members or restriction on transfer. Okay, next, terminate, set aside, modify any agreement between company managing director, manager or others. Okay, in order to stop the oppression or in order to stop the mismanagement, if the tribunal feels that the agreement that the company has entered with managing director or any other person has to be squashed, then tribunal will terminate, set aside, modify any of such agreements in order to stop the oppression. Okay, let's say what agreement will be entered with managing director or whole time director? Employment agreement will be entered, right? If the tribunal feels that those people, they are causing mismanagement in the company or oppression in the company, then tribunal will cancel their employment agreement with the company, right? Next, removal of managing director, manager or other director. If tribunal feels that any of the managing director, manager or other director is mismanaging the company or causing oppression in the company, tribunal will remove those directors. Okay, tribunal will pass an order removing those directors. Next, recovery of undue gains made by managing director, manager or director. Okay, till now, till the time application is filed, if the managing director, manager or director has gained or earned any gains for themselves by doing fraudulent activities, tribunal in its order will order to recover those undue gains which are earned by managing director, manager or director. Hope that is clear. Next, appoint such other director by tribunal to report to tribunal. Okay, it has removed the existing directors, so in their place tribunal can appoint new director. Okay, next, impose costs as it may deem fit. Okay, if for filing this application with the tribunal, if the shareholders have incurred any expenses, tribunal can also order the company or those directors to reimburse those expenses to the shareholders. Okay, so these are the powers that are available with the tribunal. Next, now tribunal has passed the order stating any of these things. Once the tribunal has passed the order, file this order of tribunal with the registrar within 30 days. Okay, company has filed this order which the tribunal has passed with the registrar of companies within 30 days. Next, if tribunal orders alteration of MOA, AOA, then company cannot without leave of tribunal alter MOA, AOA inconsistent with the order. Okay, let's say tribunal has passed an order stating that you introduce these clauses into your MOA or AOA, then company has to introduce only those clauses. Okay, it should not do any addition which is against those clauses. Okay, so the change that the tribunal has prescribed should be implemented as it is. Okay, there should not be any inconsistency in the change that the company makes in its MOA or AOA as per the tribunal, as per the order of the tribunal. Okay, next, now moving to the next section, section number 243, which deals with consequences of termination or modification of certain agreements. Now, if you see in the previous section, we have seen the tribunal by ordering will terminate, set aside or modify some types of agreements. So as a consequence of modifying or setting aside of those agreement, what will happen? So what are the consequences of such termination? Basically, the agreement between the company and the managing director or the director or the whole time director will be with respect to the employment agreement, right? So once the employment agreement between the company and the managing director or the whole time director has been terminated, then it shall not give rise to any claims against the company. Okay, now you are terminating that particular managing director or whole time director because tribunal has passed an order asking to terminate them. Since the tribunal itself has passed the order, you need not pay any compensation to that particular managing director because of his termination. Hope that is clear. Next, agreement with managing director, manager or director is terminated under section 242 normally. That means shareholders have filed an application with the tribunal with respect to the operation under section 241, and as a result of such application, tribunal has ordered to terminate the managing director or the director or the whole time director. In such a situation, such a particular person who has been terminated will be disqualified for appointment in that company for a period of 5 years. Okay, however, if company wants to appoint such a person who has been terminated, then company can so appoint only after taking prior approval of the tribunal. Okay, so disqualified for appointment in that company for 5 years without leave of the tribunal. That means by asking the permission, the prior permission of the tribunal, you can again appoint such person who has been removed as a consequence of order passed by the tribunal. This is the situation if the if the managing director has been terminated normally because of the application filed by shareholder. If central government has filed the application asking for the and as a consequence of such application, tribunal has filed an order to terminate the managing director. In such a situation, that respective person who has been terminated, he is disqualified from being appointed as managing director or whole time director in any other company. Okay, that is the difference between these 2 points. See, disqualified for 5 years in any company without leave of the tribunal. Okay, if termination is normally as a consequence of application filed by the shareholder, then that particular person is disqualified for 5 years only in that company. In the other case, if the central government has filed application under section 241 and as a consequence of that tribunal has passed an order to terminate the managing director or the whole time director or the director, in such a situation, such that respective person who has been terminated is disqualified for 5 years in all the companies. Hope that is clear. Here also no compensation will be paid to that respective person who has been terminated, because he has been terminated because of order passed by the tribunal. Why the tribunal has passed the order? Because this person has mismanaged the company, or this person has created the operation, or this person is involved in any fraud. Okay, because of the actions of that person he has been terminated. So why will you pay the compensation to him? You will not pay the compensation. Okay, so that is section number 243. Now moving to section number 245, which deals with class action suit. That means class action suit means two or more people will come together and they will file the complaint or the application together. That is known as class action suit. Now, to whom this class action suit can be filed? Obviously, it can be filed with the tribunal, right? And who can file these class action suit? Either members, that means shareholders, or deposit holders. Okay, see, deposit holders, they cannot utilize section number 241 because section number 241 can be utilized only by the shareholders. Section number 245 can be utilized by deposit holders also. Okay, and why the application, why the class action suit can be filed? See, class action suit can be filed by shareholders or depositors with the tribunal to restrain company from committing following actions. What are those actions? If company is doing anything which is ultra virus to AOA or MOA, this is the first situation. Or if company is breaching provisions of MOA or AOA. Sorry. Now, what is the difference between these 2 points? If you read these 2 points, they will look similar. See, ultra virus to AOA or MOA, breach of provisions of MOA or AOA. What is the difference between ultra virus and breach of provisions? Let me give you an example. Ultra virus. Now, MOA of the company permits the company to do textile business. Okay, so company can do only textile business. Now, apart from textile business, company is also doing some other business like software development business. Okay, so apart from textile business, it is also doing some other business. So it is going beyond which is permitted by MOA. So it is ultra virus to MOA. Okay, the actions of the company are ultra virus to MOA. Next, what is meant by breach of provisions of MOA or AOA? Let's say AOA is having a clause which states that to perform a particular activity, you have to take approval of shareholders. Okay. To perform a particular activity or to take a particular decision, you have to take approval of shareholders. Now, company without taking approval of shareholders, it is doing that particular activity. Now, this becomes a breach of provisions because after doing the activity, the shareholders can ratify this activity, right? So here it is not ultra virus to the MOA or AOA. MOA or AOA is permitting that action, but with the prior approval of shareholders. But the company has not taken the approval of shareholders. So this becomes a breach of provisions. Whereas in the first situation, MOA itself is not permitting doing any other business apart from textiles. So if you start doing any other business apart from textile, it is ultra virus to MOA or AOA. Okay, this is the difference between these 2 points. Now you can file class action suit to restrain the company from committing these 2 activities. Next, you can also file class action suit to restrain company. See, declare alteration of MOA or AOA as void. Now, the company without proper approval has amended AOA or MOA. Now, in order to declare such amendment of AOA or MOA as void, either shareholders or deposit holders can file a class action suit with a tribunal. Okay, next, restrain company or director from acting on such resolution. Okay, let's say any resolution has been passed without the approval of shareholders. Now shareholders or the deposit holders, doesn't want the director or the company to act as per such resolution, because the shareholders or the depositor holders, they have not agreed for such type of activity. Now in this situation, to restrain the company or the director from committing such action, you can file a class action suit with the tribunal. Okay, next, acting against provisions of the act. Okay, if the company is acting against the provisions of Companies Act 2013, then to restrain the company from acting against the provisions of Companies Act, you can file class action suit. Next, acting against the resolution passed by the members. Okay, members have passed a resolution to declare dividend. Let's say declare dividend of 10 rupees, but company has not declared dividend. Now company is acting against the resolution passed by the shareholders. So in this case also, to restrain the company from acting against the resolution passed by the members, you can file a class action suit with the tribunal. Tribunal will take the action. Okay, next, seek such other remedy. Okay, to seek any other remedy, you can file a class action suit with the tribunal. Hope that is clear. Next, to file a class action suit, what is the minimum required number of members? Okay, just like to file an application under section 241, there is just there is certain minimum required number of shareholders, right? Eligibility to file the application under section 241 we have discussed in section 244. Just like that, to file a class action suit, what is the eligibility? See, requisite number. In case of members, okay, if members, that means shareholders wanted to file a class action suit, then there are two types of requirements based on number of members, based on their shareholding value. Okay, if you go by based on number of members, at least 5% of the total members of the company or 100 members of the company, whichever is lower, must be there to file a class action suit. Okay, let's say the company is having some 100 shareholders. Okay, now 5% of 100 shareholders is 5 shareholders or 100 shareholders, whichever is lower, which is lower, 5 is lower. So if 5 shareholders come together or 5 shareholders give consent, they can they can file class action suit. This is based on number of members. Now going by based on shareholding, if the company is a unlisted company, that means its shares are not listed on stock market, in such type of a company, 5% of the issued share capital. Okay, if shareholders holding 5% of the issued share capital give consent to file the class action suit, they can file the class action suit. If the company is a listed company, then 2% of the issued share capital. Hope that is clear. Next, if deposit holders wanted to file class action suit, then 5% of total number of depositors or 100 depositors, whichever is lower, must come together to file a class action suit. Next, there are certain, I hope you are clear with these requisite number of members to file class action suit. There are certain important points. Similar application with other jurisdictions must be consolidated. Now let's say class action suit on the company has been received by the tribunal from various jurisdictions. Okay, group of 5 shareholders, another group of 6 shareholders, another group of 10 shareholders, they have separately filed class action suits against the company. Then all those class action suits will be combined together and resolution will be given or solution will be given. Okay, so class action suits from different jurisdictions will be combined for giving the resolution or for giving the solution. Next, two class actions for same cause are not allowed. Okay, let's say two class action suits are received by tribunal for same cause, that is company is committing breach of provisions of MOA or AOA. So to restrain the company from committing breach of those provisions, two group of shareholders have filed class action suit. So you can't file separate class action suits for the same cause. Hope that is clear. If you have received two class action suits for same cause, again they will be combined, they will be merged. Hope that is clear. So that's it. By this, we have completed discussion of prevention of oppression and mismanagement. And there is another announcement for you. We have recently launched Lecturepedia app. On this app you can download MCQs and you can also purchase courses of various faculties. You can download our app from Play Store. Okay, do check out the app, and we'll meet in the next video. Until then, take care, bye bye, see you.